for this, and of course, you are free to refer to your any submission of yours to the extent that it's related to the non-compliance issue, which is the issue before this status conference.
Happy to answer that, and I think it goes to the point that I was endeavoring to make earlier, which is this. This treaty, and indeed many statutes of state parties seeking to develop domestic legislation to enforce the treaty, speak of the court in two senses. When Article 34 speaks of the court in its corporate entity, this is the International Criminal Court. It is one entity with one seal. It is a body corporate. And within it, it contains the 4 divisions that are set out there. But you will note, sir, if you look at Article 38, for example, Article 38 talks about the presidency of the court. And Article 42 talks about the office of the prosecutor. Article 43, the registry. Now, let me give you an example of Article 48, privileges and immunities. When it says there that the privileges and immunities the court shall enjoy in the territory of each state party, such privileges and immunities as are necessary for the fulfillment of its purposes. That is the court in its corporate sense. But when we go to the question of, for example, the powers and functions of the court, for example, let's look at Article 62. Article 62 talks about the place of trial. Unless otherwise decided, the place of trial shall be the seat of the court. The seat of the court in this sense is the seat of the judicial organ. It is the seat of the judicial organ. It does not, in our very humble view, have the same meaning as you have identified in the corporate definition of the court. And when we talk in Article 62, say, of the powers of the trial chamber, now the trial chamber is a much more specific body, so that, again, the inference to be drawn there is that there is a recognition that the court functions as a corporate body for certain purposes, and the court functions as individual autonomous institutions for other purposes. And if I may say this with your kind permission, this form of structure that we have in this court, of which Kenya is a proud member, is a very unique structure in criminal jurisprudence. It is a very unique structure where you have the judicial chamber and the investigator and the prosecutor housed in one institution. Because in most jurisdictions, the professional distance between the judicial organ, that is the court, and the prosecutor, who is in an adversarial relationship with the defense, is a very serious matter. So in this, as we read the Rome Statute, I want to suggest we must remember that international best practices are where the judicial chamber and the prosecutions are completely at arm's length. Completely. I would say 3 arm's length. Because any other perception that the judicial chamber and the prosecutor are one organ would seriously do violence to our sense of justice and fair play. Therefore, we resubmit this. The prosecutor is not the court. The prosecutor is an organ of the court for functionality only. For functionality only. But the prosecutor cannot take the garments of the court and parade. The prosecution cannot parade itself in the garments of the court, demanding and invoking powers that inhere in the court itself as a judicial body. Because to do that would to create a playing field that can never possibly produce justice. That is my submission.
Thank you, Mr. Attorney General.
Another question I would like to pose to the government of Kenya. In the written submission of government of Kenya, you referred to the Kenyan International Crimes Act, the legislation which was passed in Kenya to domesticate the Roma Statute. And could you please confirm whether that is the relevant national legislation through which the prosecution request could be processed? And if so, we note that Article 2 of the International Crimes Act contains a definition of ICC, which specifically includes any of the organs of the court referred to in the Roma Statute. And the term ICC is then subsequently used in the cooperation articles in this act. Could you clarify if that definition of International Crimes Act consistent with the interpretation of Article 93(1) of the Roma Statute, which you have just explained?
Yes, Madam President, I am happy to confirm that the International Crimes Act of the Republic of Kenya is the statute that we have used to domesticate the Rome Statute. And it confirms in its main title that this is an act of Parliament to make provision for the punishment of certain international crimes, namely genocide, crimes against humanity and war crimes, and to enable Kenya to cooperate with the International Criminal Court established by the Rome Statute in the performance of its functions. Let me come, Madam President, to your question about Article 2. It is indeed true that Article 2 defines the ICC as the International Criminal Court established by the Rome Statute, excuse me, and includes any of the organs of the court that are referred to in that statute. We find absolutely no contradiction whatsoever. Article 2 is making the same recognition as the Rome Statute does, that the court exists in the first instance as a corporate body. And secondly, it exists in its distinct, individual, independent, but interdependent parts. And that's why, and I'm not a draftsman, Madam President, and I have great respect for draftsmen, and I think that the comma there is very material. The comma is very material. It says The ICC means the International Criminal Court established by the Rome Statute, comma, and includes any of the organs of the court that are referred to in the Rome Statute. When you retire to deliberate on this matter, Madam President and the court, and this statute becomes available for you to peruse, it will become clear that, like the Rome Statute itself, it makes many, many distinctions between the court as a judicial organ, the prosecutor, the registry, and other organs. And let me give you just one example. Who is required to cooperate with the court under Kenyan law? There are two ministers, in that sense of that word. There are two persons who are required to cooperate, and that is part of our submissions which we filed yesterday. One is the Attorney General, and the other one is the Minister of the Interior. And almost without exception, the facilitation by the Minister of the Interior, which is considered by the prosecution in the hundreds of letters that they have written over the last 5 years, that Kenya, over 5 years now, that Kenya has been a situation country, is that communication with the Minister of the Interior requiring the cooperation of that ministry is almost exclusively in respect of non-judicial processes. And the cooperation of the Attorney General in almost 9 out of 10 is in regard to judicial or quasi-judicial processes. And therefore, I want to answer your question by confirming that in our own understanding of our own law, we enacted Article 2, Section 2.1 of the International Crimes Act 2008 to be read in the same way as we are able to read Article 40, sorry, not Article 40. I have misplaced, yeah, Article 34. I'm calling it Article 43. And the two are consistent, and there is no controversy whatsoever. And maybe if I still have 1 minute, can demonstrate that again by going back to a question that I have already addressed relating to the warrants that we received from this court. And again, you can see the multiple usage of the word court. Because this court was approached by the prosecution to issue a warrant. The court there means the judicial organ. The judicial organ, in its absolute discretion, made a judicial order. But the transmission of the judicial order to the government of the Republic of Kenya is not made by the court as a judicial organ. It is made by the registry as an organ of the bigger corporate court. And therefore, the meaning continues to be consistent. The meaning that the court as a judicial organ and the court as a corporate body are consistent is, in our very humble view, very clear. And therefore, our statute is clearly consistent with the treaty, which was our intention. Only before I sit down to mention that whenever it is said that Kenya has failed to cooperate with the court, the very existence of Kenyan law effecting the Rome Treaty is the primary evidence of the enthusiasm with which Kenya has always embraced the court since it became a party to the court. And I have looked at how many state parties actually have domestic legislation, and Kenya is in a very unique position in that view. And I also wish to add this. I have also looked at the history of this court, and unless I have missed something, I was unable to find in the history of this court, in excess of 10 years, an occasion when the Attorney General of the Republic in question, the situation country, has come to this court in person, not by retaining counsel, in person, to say, this is what we have done, this is what we are doing, and this is why we are doing it. That, to us, is the ultimate example of cooperation, the ultimate insignia of the respect that the Republic of Kenya holds this court.
Thank you very much. Thank you very much. We would like to move on to other more specific points. Unless any of the parties and participants wish to specifically address this question of interpretation of the word court beyond the submissions they have previously made on the point.
Your Honour, Your Honour, I remember being on my feet on the previous occasion last week and specifying within Article 93 that there was the court or the prosecutor, and I couldn't remember the particular provision. During the attorney's submissions to you this morning, I noticed it's Article 93, sub-Article 5, which I've been able to note, which is an Article 6, sorry, Article 93, sub-Article 6, which is consistent with the attorney's submissions, I believe, this morning.
Thank you very much. Prosecution?
On that precise matter, can I invite the Court's attention to the very article and sub-article which Mr. Kay has referred? Article 93, sub-article 6. If a request for assistance is denied, I pause there because, in fact, this request for assistance wasn't denied until very recently. The history of the correspondence shows that the Kenyan government was consistently saying, yes, yes, we're getting round to it, until quite recently. But it is now, I accept, denied. Well, what should follow? We read on. The requested state party shall promptly inform the court or the prosecutor of the reasons for such denial. Well, this request, the request about which we are complaining, was made 22 months ago. There has not been compliance in any shape or form with that sub-article. The requests, I beg your pardon, the reasons that now advanced have come very, very late in the day. There's one other remark which I seek to make relating to something which the attorney said earlier, and it is in relation to a document to which he referred. Now, I'm aware that Your Honours will be familiar with the documents, but it is one small portion to which I would refer you, because it casts a blinding light upon the merits of the position of the government of Kenya. May I refer Your Honours to...
Mr. Gumpel, it is the intention of the Chamber that we will discuss the issues of consultation and timing of the request at a later stage.
Your Honour, I was...
So if you can confine your point to the issue of definition of the court and prosecution, I would be most grateful.
Your Honour, the points I make only arise from submissions which other parties said were relevant to your question of the definition of the court. So I make them in response to matters which have been said to be relevant to that. But in fact, this one point that I'm about to make, or one matter I'm about to draw to Your Honour's attention, which will take no more than a minute to do, is precisely on the question of whether or not within the word the court is included the organ of the court, the prosecutor. And it is a demonstration of the position which the government of Kenya itself occupied. It's paragraph number, it's at tab 16. And it's paragraph 16. Do Your Honours have it? Tab number 16 in the folder which I have produced for Your Honours. That is the Government of Kenya's filing of the 8th of April of 2013, filing number 713. That's a 20-page document. Do Your Honours have it? Yes. And paragraph 16 is on page 9. And this is what the government of Kenya submitted to the court was the law on the 8th of April of last year. Part 9 of the Rome Statute establishes a comprehensive framework for cooperation between the ICC and states parties. Article 93(1) details numerous specific types of assistance that the prosecutor and court may request from states parties, and which states parties must comply with in accordance with Part 9 of the statute. There, a clear acknowledgement, because I submit the argument they now advanced hadn't at that time occurred to them, that the powers set out in Article 93, which are, after all, the principal investigative powers which the prosecutor has, are indeed available to the prosecutor. Indeed, any submission to the contrary might be thought to be difficult to sustain. If the prosecutor can't investigate by asking for assistance under 93(1), what can it do? So those are the only submissions I make in respect of what has been said thus far.
May I,
Thank you
Madam
very
President,
much. Mr. Attorney General.
may I, with your permission, address that matter, lest it be understood that we agree with the submission. That submission is totally, factually inaccurate. The letter to Madam Bensouda that the prosecution has made reference to, which is dated the 23rd of November 2012, that cannot be described as a recent declaration by the Kenya government of its view. Indeed, in that letter, if I may read because this is important, this is what I said to her, the learned prosecutor. You will recall in our discussion during our recent meeting held on the 17th of November 2012, in which I informed you that the requests made to the Republic of Kenya must conform to the laws of the Republic. You will also recall that I reiterated that Kenya will continue to cooperate with the ICC within the context of its international obligations as provided for in the Rome Statute and the Kenyan laws. And it was important to note that Kenya has agreed to allow the ICC judicial process to proceed to its conclusion. And I said further, we draw your attention to the issues raised in our letter of 7th November. We draw your attention to the distinction. And when I finalized on the following page, I said, our reading of this part of the statute, the Republic contends that the request has to be from the court, which is distinct from the prosecutor, and that a court order has to be in place before this request is in force. In our view, a judicial process is necessary in order to avail third parties a chance to present their cases. It would be totally inaccurate to suggest that we made up our mind on what the law is a year later. We knew what the law is a year earlier, and we stated it. And I want to finally draw your attention to the document that the learned prosecutor has read. And I'm constrained to observe that he has read it selectively. He has read the preambular part of the document in which we were beginning to introduce the idea of the distinction between the court as a judicial organ and the prosecutor as an officer and an organ of the court. Because if you proceed with the paragraphs that he did not read, which I will not read, paragraphs 18, 19, 20, 21, 22, 23, we made the same argument. And we said, there is a distinction. In paragraph 23, we invited the prosecutor to come to this court, and seek an interpretation. That was 1 year ago. It would not lie in the prosecutor's mouth now to suggest that we have only recently taken this position, or we have only recently become clear what the law is. Finally, I think that I am obliged to Mr. K for bringing the attention of the court to Article 93.6, which in my very humble view should bring this matter to a very clear end. It says, Article 93.6, when it is dealing with forms of cooperation, if a request for assistance is denied, the requested state shall promptly inform the court or the prosecutor. Do we need any other evidence that the prosecutor is not the court? This section actually recognizes that a state that does not wish to deal with the prosecutor, another state other than Kenya, Kenya is quite happy to deal with the prosecutor, can come directly to the court itself and say, the prosecutor was asking us for the following assistance, and we have told her that we can't give her. What did the Kenya government do? It said, we hold the prosecutor in the highest possible professional regard. As one professional to the other, I did not ignore her communication. I wrote to her and said, I am unable to facilitate this sort of cooperation because of the following legal reasons. It cannot now lie in the lips of the prosecutor to allege that we denied assistance and did nothing. No. We informed the prosecutor that of the following of your requests have been facilitated. You wanted a court file from a place called this and that place? Have it. You wanted motor vehicle records of the owners of this vehicle, have it. You wanted this and the other and the other and the other, have it. But of this and this and the other, please go and get a court order, because that is the requirement of the law. Thank you.
Madam President.
Thank you very much. Mr. Gaynor, on this specific point?
Yes, on this specific point, Madam President, you referred to Article 2 of the International Crimes Act of 2008, which sets out clearly that the term ICC includes any of the organs of the court that are referred to in the statute. Now, when the Attorney General receives a request for assistance pursuant to paragraph 1I of Article 93 of the statute, he is bound by Section 104 of the International Crimes Act that expressly deals with requests coming from the ICC under that specific sub-article of Article 93 of the Rome Statute. Now, in the opening words of Section 104, the words are, where the ICC makes a request under paragraph 1I of Article 93 of the Rome Statute for the provision of records and documents, including official records and documents, the Attorney General shall give authority for the request to proceed if he is satisfied of two things. Now, my point at this stage, I'll return to this article later during my submissions, is that it's absolutely clear that if the request comes from the ICC, which is defined in Section 2 to include the organs of the court, the Attorney General must act. Now, if the Attorney General really, truly believed that the term ICC in Section 104 did not include the prosecutor, he was under an obligation immediately to come before the court under Article 93(3) of the statute, Article 99(4)(b) of the statute, and Article 97 of the statute. The obligation lies squarely on the state party to consult with the court. It does not lie on the prosecutor to litigate the matter. Thank you, Madam President.
Thank you very much. And I think it's a very good cue to go to the another issue, which is national barriers to execution of the request. And as I said, as for the issue of consultation and timing, who said what when, we will come back later, and parties and participants, including the government of Kenya, will have ample time to discuss this issue. But before going into consultation and timing issue, the Chamber has several questions which it would like to ask government of Kenya about the national barriers to the execution of the prosecution request. And after that, of course, parties and participants will be given an opportunity to make submissions. Mr. Attorney General, in your written submission, you highlighted for the Chamber certain provisions of domestic law which your government submits create an obstacle to the execution of the prosecution's request. These obstacles include a right to privacy enshrined in the Kenyan Constitution, as well as certain provisions of national legislation providing for the non-disclosure of an individual's financial information in the absence of consent. The first very factual question. In respect of the information for which it is submitted that consent is required, has the government of Kenya sought the consent of the relevant individuals, specifically in this case of Mr. Kenyatta? And if you prefer to answer this question not in open session, we can go into private session, if you prefer.
I thank you, Madam President. I'll start with your last question. Has the government of the Republic of Kenya sought the consent of any of the accused persons before this court to release any documents that it may have? The answer is simply no. No, for very good reason. And that is the reason that has brought me to this court to explain. And it is fundamental to the confusion that has pervaded the submissions that were made in the absence of the Kenya government. The Republic of Kenya is a sovereign, autonomous, independent state. The governments that run the state of the Republic of Kenya are different. And every 5 years, voters go to an election to make a determination whether they will elect one person as opposed to the other. Madam President, since Kenya became a situation country, we have interacted with the court as the sovereign state of the Republic of Kenya. You yourself have said in the ruling to my amicus application that the government of Kenya is not a party to proceedings. And therefore, my own understanding of the law was that as the chief law officer of the Republic of Kenya, it was my duty to keep a clear, independent distance from the prosecution and from the defense, and to have a direct engagement with the court. I did not feel that it was in my place to contact the defense and to suggest to the defense how the defense should conduct its case, including facilitating or not facilitating these documents. Indeed, the further answer to your question, Madam President, is this. It is the duty of the prosecutor, in my understanding of best international practices in criminal jurisprudence, to seek from the defense a concurrence at the disclosure stage of the case. Let me, and this is not a lamentation, it is a statement of fact. One of the difficulties that the Republic of Kenya has had in this case, and why I filed my first amicus application, is because submissions were made in this case by all manner of parties regarding matters that were totally outside our knowledge. We, as you know, Madam Chair, have no access to the thousands upon thousands of confidential documents filed in this court. The Republic of Kenya does not know the list of witnesses. It doesn't know who they are. It doesn't know where they are. It doesn't know their identity. It doesn't know who has agreed to testify, then refused to testify, and it has no way of knowing. But that has not stopped the prosecution, and unfortunately sometimes other parties in the court, to make allegations about the government of Kenya relating to issues that the government of Kenya has no way of finding out. Let me give you an example. both the former prosecutor and the current prosecutor have carried out a long public lamentation about the alleged obstruction by the government of Kenya, which they claim is manifested in the intimidation of witnesses. On more than a dozen occasions, Madam President, I have said to them, who are your witnesses if you want me and the Republic of Kenya to protect them? The answer, Your Honors, may shock you. The answer has been, we cannot tell you the names of the witnesses because they are not safe with you. So I am guilty of not protecting witnesses whose identity I don't know, whose identity I will not be given.
Mr. Attorney General, I'm so sorry to interrupt, but we have many more questions to ask, and the time is rather limited. So I plead you not go into details about the protection of witness issue, for example. Thank you.
I stand corrected, and I will go to your other specific point. And my answer is as follows. There is another misapprehension of the law by the prosecutor, which runs very deep in the proceedings before this court. And it is this, that if the prosecutor wishes for anything whatsoever to be done within the Republic of Kenya relating to this case in whatever manner, that which the prosecutor wishes will be done irrespective, A, of Kenya's own understanding of its obligations under the Rome Statute. Our submission is that that is not true. The government of the Republic of Kenya does not take legal advice from the prosecution as regards what its obligations are under the treaty. The government of the Republic of Kenya takes legal advice from its law officers. That's point number one. Point number two, the prosecutor seems to be under a misapprehension that treaty. The government of the Republic of Kenya irrespective of what of the Republic of Kenya takes legal advice from its law officers. That's point number one. Point number two, the prosecutor seems to be under a misapprehension, including and fundamentally from its law officers. That's point number one. Point number including and fundamentally
from Mr. Kenyatta. And correct in understanding your answer to be that you didn't sought the consent of Mr. Kenyatta because you are prohibited by Kenyan law to seek the consent, or you are not obligated by Kenyan law to seek the consent?
Madam President, it is neither my duty home statute nor my duty under to seek such consent. I have said that it is in an advanced system such as is before this court, prosecutor on the defense, whether they will consent to the production of any. As I sit here now, and I'm afraid again it sounds like a lamentation, I don't know what the defense and the prosecution have exchanged by consent. I don't know what they admitted to or did not. What I have said to you, honorable judges, is this. If the Republic of Kenya were to descend into the arena of this conflict and were begin to make demands of the accused person, our position as an independent state party, not party to the proceedings before the court, would be irredeemably and irreversibly compromised. And therefore, my answer is the duty. Now, the only, then we have a stalemate because we don't have a court.
We have only 2 minutes to 11. Adjourn right now, take 30 minutes break, and come back to this courtroom after the hearing is adjourned.
All rise. We will lever.
including and fundamental
All rise. We will lever. Please be seated. We will just swap. Please be seated. We will just swap.
To the representative of the Republic of Kenya, if I may. If I understood correctly, said in the previous session, this international, distinction between judicial request and non-judicial request. And judicial request, you need a court order, while non-judicial request, you don't need. And in Article 93(1) of the Roma Statute, there are various types of requests from the court enumerated from A to L. In your interpretation of Roma Statute, some of them are judicial requests and some of them are non-judicial requests. Right? I'm asking because there is also a dispute between the prosecution and the government of Kenya about the legal basis of the prosecution request for financial information. Prosecution's view is that this request was made on the basis of 93(1)I and L, while Kenyan government interpretation is that this request was made based on 93, was made on the basis of 93(1)I and
that Article 93 contains both judicial requests, but on the main substance, it enumerates judicial requests. That is to say, it requires, for example, on the main, the taking of legal within the state party. In most of the provisions they are set out, the invoking of domestic legislation or law. If, for example, you look at 93(1)A, the identification and whereabouts of persons or the locations of items, it requires no judicial intervention of any nature because it can be complied simply by the state party providing information of the scene of the subject matter of the proceedings, or the identification of persons. For example, if we received a request that asked, in Kenya, under your management of government, tell us who is responsible for the registration of persons or the issuance of passports. There is no requirement for a court order, and we would be able to comply with that. That is also true in the main. If you go to I, the provision of records and documents, including official records and documents. There are many records and documents, and we would be able to comply with that. That is also true in the main. Compromise the privacy or the personal rights of any person. These proceedings before this court, we have already, if I remember correctly, the prosecution requested of us to provide indicating ownership of certain motor vehicles. We don't need a court order. There is no privacy about the ownership of a motor vehicle. It is a matter of common and public knowledge, and that's why we complied directly. On the main, however, 93 requires certain other limitations that call for judicial support. For example, facilitating the voluntary appearance of persons as witnesses or experts before the court is a matter within the consent of the person. The court will say, we understand that in Kenya there is an officer called the chief, who is a person who runs the government's laboratories. He has agreed to come to The Hague to talk about this process that he carried out. Can you facilitate? That means, can you issue him with a travel document? Can you give him leave from his work? We don't need a court order, because that is within our mandate, especially if he confirms. However, if we require the questioning of any person being investigated or prosecuted, a whole regime of the statute itself and of Kenyan law kicks in, because this person being investigated or prosecuted has rights under the Rome Statute, under the procedures of this court, and indeed under Kenyan law as well. A Kenyan court asked to question any person, because it is a judicial process. I cannot call this person to my chambers and question him. It would be worthless, because I'm not a judicial officer. If I took a step down, a Kenyan court asked to question any person, because it is the person from whom I have taken a statement, to dispute the contents of his statement, then you can see, Madam President, it's a Pandora's box. The way to do it would be to have this process referred to, in the past, referred to a judicial organ, and that judicial organ then uses the normal rules of an investigation and prepares evidence taken under oath. Can take evidence under oath for purposes of supporting a judicial process. So my short answer to your question is this. It is true that 93 contains both sorts of procedures. And it is also true that the prosecution itself, in believing that processes could be treated as similar. And before I wind up, if you look at I think I is very instructive, Your Honors. And if I may read it, it says, any other type of assistance which is not prohibited by the law of the requested state. Any other assistance. My own understanding of the rules of statutory interpretation are this, that where the statute clearly enumerates the draftsman intended that each article be appreciated as such. And where there is a general provision of this nature, it is also to be understood in the context of its limitation. Any other assistant not set out in 93(1)(a) to K can only be made. It is also to be understood in the context of its limitation. Any other assistant not interpretation is a 93 request, and we have said it is prohibited by domestic law. In our view, nothing could be clearer. That is a prerogative of the receiving state, its own law. In fact, the reason we are here before you today, Your Honors, is because the prosecution has done something unprecedented in international judicial proceedings. It has sought to impose its own interpretation of the law of another jurisdiction on the officers of that jurisdiction whose constitution is to make the interpretation. I have no, in my experience, which is not as extensive as that of the honorable judges of this court, but is close to 3 decades of the law. I have always understood the law to be that an international tribunal cannot purport to interpret the law of a sovereign state in a manner inconsistent with the way the organs of that state interpret that law. And this court, or indeed any other international tribunal, should not place itself in a situation where the Supreme Court of the United States has declared the law of the United States to be X, or the Constitutional Court of Germany has declared German law to be X. But the International Criminal Court declares that domestic law to be something else. That would be a recipe for it to be X. Or the Constitutional Court of Germany has declared German law to be X. But the international jurisprudence is consistent on this point. In Kenya, the Attorney General is the chief legal officer of the Republic. Of law is final, except where dispute is referred to a judicial organ that overrules that interpretation. So, as we sit here this morning, the law has been stated by the Office of the Attorney General. Thank you.
Thank you very much. Please rest assured that this court would like to try to impose any specific interpretation of your law, but at the same time, this is for this court to interpret and adjudicate the Roma Statute and whether any acts of anyone are consistent with the Roma Statute or not. The related question, as for this judicial request, in order for you to get a court order, do you always need an order from the chamber of International Criminal Court? I ask this question because in some jurisdiction, in the context of international cooperation on judicial matter, some jurisdiction Attorney General can get a court order upon the request from the competent authority of requesting state, which is not necessarily court.
Thank you very much, Your Honors, for the opportunity.
Upon the request from the competent authority of requesting state, which is not necessarily court.
Of Kenya in any Kenya is the absolute Director of Public Prosecutions, who is an independent constitutional office, and as I set out in my written submissions, is not subject to any direction by any body or authority. And as Your Honors will retire to consider all the written material, as Your Honors will find out, this is at the heart of the including and fundamental including and fundamental so that as we speak here today, Madam President, the process is going through the courts under the stewardship of public prosecutions. I have no constitutional authority, has no constitutional authority. The minister has no constitutional authority to direct him to stop doing it, to halt anything else. That would be a violation of our law and our constitution. And discuss what was alleged to be the interference state in the process is coming. But this is the basis of the misunderstanding. There is a misunderstanding that in Kenya, all we need to do is to receive an order from a court. Then it is effected directly by the recipient. I can't do it. If I received an order about financial records, I would have to go to the governor of the central bank, an independent institution under the Constitution. And it says so in the Constitution. The Central Bank of Kenya shall be an independent institution that cannot take instructions from any other body or authority. The same is true of court. Many times I have been asked by the prosecutor, give me a file of a case that was conducted in a certain place at a certain time. And all I have been able to say is, I have transmitted your request to the registrar of the High Court of Kenya, who cannot take instructions from me as to what they will do in their judicial capacity. So I wish to confirm, therefore, that this would have to the registrar of the High Court of Kenya, who cannot take instructions from mandated authority. That is the normal procedure in Kenya. Thank you.
I'm sorry, Mr. Attorney General, I'm a bit confused. As for Central Bank of Kenya, if there is a court order, I mean order from the Kenyan court, they are under obligation to disclose certain materials.
The Central Bank of Kenya is the regulator of banks, all banks. And in terms of processing requests, would send that sort of request to the regulator. Then the regulator would send the request to the specific bank or banks. In theory, it is expected that the Central Bank of Kenya would have access to information or would have the authority to require information from banks. But banks themselves, in responding to the central bank, would have to comply with the Banking Act, which itself says no information may be disclosed except with the consent of the depositor or the client. So that is the problem. May I clarify something that you asked me earlier, and my mind was not firmly on it, and it is this, Madam President. You asked me whether I ever approached Mr. Kenyatta for this purpose, or Mr. Ruto, indeed, for the general purpose of the request. And I told you I didn't, and I gave you the reason then. As I had coffee, I thought of another reason as well, even more fundamental. The request to supply information relating to the financial records of the two accused persons was done confidentially. And had I used communication given to me confidentially by the prosecutor,
Mr. Attorney General, this is open.
Financial records of the two accused persons was done confidentially. And had I discussed the matter on record.
Okay.
Yeah, and we agreed that there was a mistake on the part of our first file disclosed. This court reprimanded us for having disclosed the information, and we were apologetic. It was a mistake, but now it's a matter of public record. But I have explained why it would have been a violation of the treaty and the rules of this court to have discussed it with the other parties. Thank you.
Thank you very much. Another related point, I see, for example, in Article 79 of International Crimes Act of Kenya about producing documents or other articles. I think this article corresponds to Article 93(1)(b) of the Roma Statute. The Article 79 of International Crimes Act says, if the Attorney General gives authority for a request relating to the production of documents or other articles to proceed, a judge of the High Court may make an order requiring their production. Does this mean, for example, if the request was made on the basis of Article 93(1)(b), your office will process this request and send it to the judge of the High Court, and judge of the High Court may make an order requiring their production? Is that correct interpretation of the law of Kenya?
That is not correct. What is correct, Madam President, is this. If the Attorney General is satisfied that a request for the production
of the law of Kenya?
That is not correct. What is correct, Madam President, is whoever is responsible for the maintenance of these records to produce them. Supposing, for purposes of argument, that person did do it timeously. In of the cooperation required of the Attorney General can notify a judge of the High Court that we have been requested by the prosecutor of the International Criminal Court to provide the following information.
Mr. Attorney General, I'm so sorry to interrupt. You are speaking too fast, and interpreters are having difficulties. Could you just a little bit slow down?
Can I start again then? Madam President, Section 79(1) of the Act, a situation where the Attorney General has been persuaded that documents or articles required by the court, the prosecutor, ought to be released to the prosecutor. And I'm using the example here of the registration of motor vehicles, which is because it is an item we have already dealt with the prosecutor. If I have made that determination and I forward my recommendation, my instruction to the registrar of motor vehicles, and I say, release to me immediately the logbooks, copies of the following motor vehicles. Supposing he doesn't do it, to the registrar of motor vehicles, and I say, release to me immediately the court can make an order. You have to look at the language there again. The language there is may. The language is may. The court itself, to whom I have complained that the director of motor vehicles hasn't given me documents, can evaluate afresh whether I had made the right decision. The court is under no obligation to go by my order. The distinction here, which is important, Your Honors, is that in respect of an application, under 93 of a judicial character, the consent of the court must be sought ab initio. The intervention of the court must be sought at the beginning. And let me give you an example. (93)(1)(h). The execution of searches and seizures. If I receive the execution of a search and a seizure, I would have processed that within the domestic law of Kenya, because I would have to call the Inspector General of Police and say to him, we are required by the International Criminal Court, by this order, signed by these judges in this manner, for you to conduct a search and to seize whatever it is. That is a process that the Inspector General himself, because he would be looking at a court order from here, would be required to enforce within the domestic machinery of the criminal justice system in Kenya. And therefore, that is a different problem from the one anticipated by 79(1). I hope I have answered your question.
Thank you very much. I may be repeating myself, but I appreciate if you can help me. Let's take example of bank records. If this chamber is to make an order for production of the records of the bank, it's chamber's order, not prosecution request. What will happen be for you to go to central bank, and central bank will contact with relevant banks, and if banks cannot produce the required documents because of banks, for you to go to central bank, and central bank will contact with
the accurate sequencing would be as follows. If there was a proper application before you in the proper manner, and there was an appropriate order of this court, the order would be received by me. And because it is an order of the investigation and prosecution, I would transmit those documents to the Director of Public Prosecutions. In my own understanding of the law, which I believe would be his as well, he has that order before the High Court of Kenya, and he would say in his application, I have received this order by the International Criminal Court asking me to obtain bank records relating to X, Y, and Z. I am mindful that I am required to execute this order in accordance with the procedures of Kenyan law. And therefore, I have come to this court to request this court to give me an order that I will serve on the central bank, and where we know the relevant banks, the specific banks requiring this information. The minute the DPP initiates that judicial process in Kenya, two things may happen. A, the Kenyan court may, ex parte, without hearing. The minute the DPP initiates that judicial process in Kenya, in short, Madam President, right in the general sense that we would require to domestic process is different. We don't begin with the order from the court and serve it. We begin by taking the order of the court to a Kenyan court. I must add this, with your permission. I have statutes in other countries domesticating domesticating the Rome Statute, and the procedure is consistent. I have looked at the procedure in South Africa, in Australia. It is consistent. There are those things that will not be done without a domestic court process. And there are those things that can be done without a domestic court process. Thank you.
Thank you very much. Judge Henderson has a question.
Yes, thank you, Good afternoon, Mr. Attorney General. Thank you very much for coming here to assist us as we grapple with this issue of the issue before the Court of Non-Compliance. I want to ask some questions, essentially to, if I may, tease out ultimately who is responsible for the execution of requests, as I think this is integral to us understanding the process, and it also featured significantly in your written submissions, which we received yesterday afternoon. So perhaps, if I can just catalog some of the provisions which I thought might have been relevant, but ultimately, as you persuade us individually and collectively, I think this may be helpful. Afternoon. So perhaps, if I can just catalog some of the provisions. 88, which provides for procedures under the national law. So at the legislation which domesticated the Rome, which is, I think, the International Crimes Act, number 16 of 2008, which locates within yourself, Attorney, 3, certain responsibilities for the execution of requests. And of course, I also looked at the Constitution of Kenya, which is the supreme law, and of course, there's a body of Commonwealth jurisprudence which locates and understands respective constitutional authority. And with respect to the Constitution, I looked at, if you'll just bear with me a moment, Section 130, subsection 1, which deals with the powers of the President under the Constitution, and in particular, subsection 3, which deals, if I could just quickly set it out shortly, chairing of cabinet meetings, directing and coordinating the functions of ministers and government departments. And then this important one, subsection 5, or subarticle 5, I beg your pardon, which also locates with him the ultimate responsibility under the Constitution of ensuring that international obligations of the Republic are fulfilled through the actions of the relevant cabinet sections and departments. So the question which I therefore want to really seek your assistance on is ensuring that international obligations of the Republic are fulfilled through the actions of the... Who does one turn to? It can't be that, to. Yes.
Thank you very much. I to refer your honors to my filing, which you very graciously accepted to in the morning because I question at some length. And I have done that on the basis that, and I don't want to rehash that argument.
Right, because it wouldn't enhance your argument or bolster it if you were to repeat it, because I can assure you we have read it.
Thank you. Thank you very much, Your Honor. Suffice it to say this, that one of the reasons I approached this court to allow me to come, as I have done here today, to address this question is because the prosecutor and the representative of the victims repeatedly said on record that the President of the Republic of Kenya, Uhuru Kenyatta, is responsible for failing to cooperate or force the machinery of state to cooperate with the court. I don't want to rehash again what I have said in my 31-page filing, except to make this point in a preambular nature. The President of the Republic of Kenya is not, to rehash again what I have said in my 31-page filing, except to make this point. Be under our constitutional dispensation responsible for the compliance of the Republic of Kenya with any request. The answer is a simple one. The Constitution of Kenya donates to independence of state. The Constitution of Kenya donates to independent organs and officers of state authority and jurisdiction to deal with certain matters in a manner that does not require them to be guided by any other person or authority. And I have already given you an example, but I'm happy to give you another one and another one. And the first one is the Office of the Director of Public Prosecutions. The Director of Public Prosecutions cannot be instructed by the President to prosecute or stop prosecuting any individual. And I know, Your Honor, you are a Director of Public Prosecutions, and you would appreciate that. Madam Bensouda herself has been a Director of Public Prosecutions. It would be an anarchical situation in a democracy if persons were to be held before a court because the Director of Public Prosecution has been instructed by any other person, and he has done so without regard to the evidence and the law. I can assure you, in Kenya, it would not happen. Number two, take, for example, the Office of the Attorney General. The Office of the Attorney General is an office in the executive. But the constitutional mandate of the Office of the Attorney General requires the Attorney General to make independent, objective decisions. And that's why our Constitution says, as you have rightly pointed out, your executive. But the constitutional mandate of the Office of the Attorney General requires the Attorney General to defend the law. It is stated in this language, if I may. The Attorney General shall promote, protect, and uphold the rule and defend the public interest. The Attorney General cannot be asking individuals in government, including other ministers, what is the public interest? Because the Constitution says it is his business to promote and uphold the rule, to know what the rule and the law is. I could go on and on and on. The President of Kenya cannot direct the Electoral Commission to declare a result in the election in one way or the other. It cannot. The Republic of Kenya cannot advise the Judicial Service Commission to recommend one judge as opposed to another for appointment. And therefore, just to summarize, our Constitution is replete with independence and autonomy for institutions. And the President cannot assume responsibility for how those institutions function. But what about Section 1325 has drawn my attention to? What about the responsibility of the President to ensure that international obligations of the Republic of Kenya are fulfilled through the actions of the relevant cabinet secretaries? Indeed, that is the heart of the matter. If the drafters of the Constitution, and I must confess I was one of them, intended that this Constitution should impose on the President personally this responsibility, it would have stopped at that. The President shall ensure that the international obligations of the Republic, I was one of them, intended that this Constitution should impose on the President personally. I'm sorry, Honorable.
I also ask you to consider the impact or the relevance of Sub-Article 3, which deals with because if there is an impasse, or stuck as it were, is everybody to sit on their hands, or is it that the general obligation to cooperate under the statute has to be given effect to? This is what I would like your help with.
I appreciate that, Your Honor. If I have your permission, if I summarize on the first argument, then I'll come to that. The duty of the President of the Republic of Kenya in the fulfillment of Kenya's international obligations is to ensure that there is in place a responsible cabinet secretary for each purpose. For example, Your Honor, if Kenya is a party to the International Criminal Court Statute, the President of the Republic of Kenya is obliged to ensure that there is in his government an Attorney General to whom can be transmitted. 1. 2, that there is a Minister for Foreign Affairs to whom the statute makes reference. And 3, to ensure that there is a Minister of the Interior to whom a specific request can be. The failure of the President's mandate would arise if he had failed to appoint responsible persons as required by the treaty and the law. In Kenya, there is no such problem. Is there an attorney request can be? The failure of the President's mandate would arise if he had is concerned vis-a-vis the Rome Statute, he has discharged that obligation. What will the Attorney General if he receives a request from the court? The President does not know. Nor should he know, because that is an independent function donated by the Constitution to the office holder. What will the Minister of the Interior do? The President doesn't know, and he doesn't need to know. What the President needs to know, and what he knows, is that there is an independent officer serving in that position. And I think the complaint that Your Honor can entertain in this court or in an international forum is to say the government of the Republic of Kenya is not living to its treaty obligation. Why? Because it is obliged to have an Attorney General to whom we can take a request. The President has failed to appoint an Attorney General. It is obliged to have a Minister of the Interior to whom we can take a request. The President has declined to appoint such a person. Thirdly, it is obliged to have a Minister of International Affairs to whom we should make, and the President has failed to do it. That then would be a failure of the President's constitutional mandate. Is that the situation here? Not at all. The three principal persons identified in the International Crimes Act as the persons required to interface with the court exist. And, in addition, practically have been in communication with the court. In my tenure as Attorney General, I have dealt with three different ministers of the Interior. And I have seen every correspondence from the court to these three ministers. And there has never been a breakdown. I have dealt with three different ministers of the Interior. Have been available for that purpose. Another case that the President of Kenya conceivably can, for what individually we are doing in furtherance to our individual mandate, either is based on a total lack of appreciation of our law or is just flippant. You asked me, Your Honor, what would happen if there was a total breakdown in the machinery for cooperation? I must thank you for asking me that question, because you have given me an opportunity to point out the exact circumstance that the drafters of the Rome Statute anticipated when they thought about a referral to the State Parties Conference. That is what can go to a State Parties Conference. So fundamental, it would go to the heart of the state's commitment to its international obligation under the Rome Statute. I make no comment, we'll have an opportunity to do so, as to what now the prosecutor purports as an afterthought can be taken to the State Parties Conference. I'll come to that. But let me, before I finish, make these points because they are in my submission, and I need to restate them. And they are this. I have been in the office of the Attorney General since September 2011. That date predates the date that the Honorable Uhuru Kenyatta was elected to be President of the Republic of Kenya. An argument that suggests that everything I did a year earlier, a year and a half earlier, 2 years earlier, was dictated upon by a person who had not assumed office is absolutely ridiculous. That everything I did a year earlier, a year and a half earlier, 2 years earlier, how would I have anticipated that I should fashion the court in anticipation of an outcome of an election more knowledgeable than I could ever be in those circumstances, had confirmed was a contested election. There were persons running for those offices who had popular support. Finally, I want to place it on record, because I have stated it in my statement. At no time did I receive or have ever communicated, received any direction or suggestion or prompting as to how my intervention with the court should be. I have made those decisions myself based on my knowledge and my experience and my learning, which a third lawyer or a fourth one may find to be inadequate, but I made them in good faith. Thank you.
I just want to ask you one last question, and of course give the other parties an opportunity to deal with the same point if presiding judge permits. What efforts have you, attorney yourself, pursued to ensure these specific requests that are at the heart, the nub of this particular application today?
I must say, if what Your Honor means is what have I done about the requests regarding financial statements, nothing went beyond the, I must say, if what Your Honor means is what have I done at an independent forum, I considered myself then, as I do now, to assume that the prosecutor was no longer in this particular disputed area of cooperation. Indeed, until the application made a few weeks ago, or a few months ago, this issue had become moot. It had become moot because two lawyers reading the same set of laws had come to two different conclusions in what the law required. In a position, Your Honor, to act in a manner inconsistent with my own interpretation of the law, and indeed my own conscience on this matter, because I never entertained a doubt then, nor do as I stand before you, that the prosecutor as a prosecutor is not entitled to this form of material without a court order. That is the reason I have not pursued the matter further. I hope I have answered your question, Your Honor.
Thank you very much. Now I would like to give. Now I would like to give the floor to the other parties and participants. But before that, I have a very practical question to ask Mr. Attorney General. So I understand that your position is that you need a order from this chamber in order to proceed with the request for financial record. In that case, could you provide an indication of how long from the issuance of you need a order from this chamber in order to proceed with the request for financial record? In that, you can even give us an indication or number of days or months, this kind of that will help us.
I appreciate your question, Madam President, but I regret I would have to go back to my original, which is this. Would deal with a request of that nature are independent and autonomous. I don't control them, controls them. And if I received an order, I would pass it to the DPP, pointing out our obligations under the law. But I cannot tell him, I have directed you to start tomorrow morning, and I have directed you to finish by. I have no such power, I have no such authority, and nobody in Kenya has such an authority. If he went to a court, that court has its own docket. He can make an argument to the court to prioritize the hearing. The court is independent. The court can consider what he says, but the court is independent. Even if the court made an order, there is an appellate mechanism. I can't stop a person affected by such an order from preferring an appeal. The DPP cannot stop him. The Chief Justice cannot stop him. That process would have to go on. We have a Supreme Court. It has its own docket. If this person were to say that there is a novel point of international or constitutional law, and the Supreme Court decided that there was, neither myself, nor the Chief Justice, nor anybody else can interfere with the docket of the Supreme Court. Would it take a month, 6 months, 1 year, 2? I don't know, and I would not speculate.
Thank you very much. It's very candid and clear.
Neither myself, nor the Chief Justice, nor anybody else can interfere with the docket of the Supreme Court. Would it take a month, 6 months?
Any issue, including the points raised by my colleague Judge Henderson. But again, I would like to remind you of previous written submissions. I'd like to start with prosecution.
I'm grateful, Madam President. In response to some of the things that my learned friend has said, I pick up first his assertion in response to His Honour Judge. The letter which he wrote on the 23rd of November of 2012 was on the matter, that he'd invited the prosecutor, the ICC prosecutor, to go to court, and that hearing nothing more, he assumed that she was no longer interested in this material. Meanwhile, the attorney himself was quite clear that such requests had to be made by means of an order of the chamber rather than simply by a request of the prosecutor. Can I take, Your Honour, to that letter and indeed to what followed, because it demonstrates with the greatest respect to the attorney that what he's just said is quite inaccurate. The bundle which I provided Your Honours with this morning, the tabbed bundle, has that correspondence in chronological order. And the attorney's letter is at tab 10. The first thing I would observe is that the statement made by the attorney that certain portions of the request, RFA 45, the document which originated this whole dispute, had to be accompanied by a court order, is restricted that certain portions of the request, RFA with regard to the request, and he's saying there, to freeze bank accounts. And he goes on to say that there needs to be a court order for that. I must emphasize that the request for assets to be frozen forms no part of our application today. I accept that the position of the government of Kenya in respect of that request has been completely irrelevant so far as these proceedings are concerned. Now let us turn, if we may, to what the attorney said was the position of on the 23rd of November with regard to all the other requests. That's at the beginning of this same letter. The requests for tax returns from the Kenya Revenue Authority. What does he say about that? He goes, I'm sorry, let me take it in turn. The request for tax returns, para 1. Then on the next page, records, bank accounts from the Central Bank of Kenya, post office savings banks, and other financial records. They're set out from 1 to 6. What is the position of the government of Kenya? Is it saying you must have a court order? The chamber must have authorized this? No, it isn't. It's saying on the 23rd of November, with regard to these requests, we have transmitted the request to the competent authorities, and we will revert as soon as we have relevant information. So far from it being the position of the government of Kenya, as I understand the attorney to say, that he'd closed the correspondence off in November, he'd said, you're not having this unless the trial chamber or the pre-trial chamber orders it. He was saying exactly the opposite, save for the freezing, which has got nothing to do with the case. He was saying, we're on the case, we're dealing with it, don't worry. And as for that being the end of the matter, and that at that stage, hearing nothing back, he assumed that the prosecutor, as he put it, was no longer interested, I shan't take you in similar detail, but tab 11, prosecutor writes back like a shot, 6th of December. I don't agree with you. You need to hurry up, please. I'm sorry if I'm using rather. He assumed that the prosecutor, as he put it, was no longer interested. I shan't take you in similar detail, but tab 11, prosecutor in respect of certain requests, he says that they are carrying inquiries out. With the financial requests, his only response, once again, is to do with the freezing of certain assets. He says nothing to indicate that his previous assurances that these records, the records you, Your Honours, are in, were being obtained, is no longer the case. The prosecutor writes back on the 12th of December at tab 13. She restates her position. At tab 14, the attorney himself writes back. Again, he says, you can't have the freezing of the assets without an order. But he says nothing to indicate that the position of the government of Kenya has changed with regard to the financial records. And the correspondence continues through February, and then with the government of Kenya's filing, and culminates in June with the very clear statement of the government of Kenya in the filing which is at tab 18, which I've already drawn to your attention and will not draw to your attention again. But in essence, they're saying, yes, we accept the prosecutor has the right to make these applications. So the submission which my learned friend made is simply unsustainable. The correspondence didn't finish then. It was quite plain that the prosecutor was still highly interested in this material. And the government of Kenya had never stated that there needed to be an order by the chamber in order for the government of Kenya to comply. In fact, they'd said the opposite. They'd said, we're on the job, we're dealing with it, we will provide it. That's the first point that I seek to deal with. The second is this. The attorney, of course, has the advantage of all of us. He is not only a Kenyan lawyer, but he is also the senior law officer of the Republic of Kenya. And therefore he speaks with a certain authority when it comes to matters of Kenyan law, and the advantage of all of us. He is not only a Kenyan lawyer, but he is also the senior law officer of those representing the prosecution at the International Criminal Court, try to interpret Kenyan law because it suggested they're not competent to do so. I say all of that by way of proviso, because when His Honour Judge Henderson asked the attorney to comment upon, to elucidate paragraph 132(5) of the Kenyan Constitution, which sets out the President's duty, the answer which the attorney gave was, firstly, all the President has to do in order to comply with his obligations is to appoint independent officers, the important one, of course, in this case, being the attorney himself. And that is the whole of the President's duties. Well, the reservations. I'm not a Kenyan lawyer. But that appears to fly in the face of common statutory interpretation and indeed common sense. It can't possibly be the case that where you have a duty to ensure that the state of which you are a head complies with its obligations, its international obligations, you can discharge that duty simply by appointing somebody independent and saying, well, it's up to them now. Of course, your duty has to continue to ensure that that independently appointed person is actually doing the job. If he sits, as the attorney said a moment ago, on his hands and does nothing, it won't satisfy your constitutional obligation to say, oh, well, that's not my business anymore. Independently appointed person is actually doing the job. If he sits, as the attorney said a moment ago, on his hands. Focus for a moment on the word independent. I have no plan of independent mind. Indeed, exercise his functions independently and perfectly properly. But he isn't, in fact, independent of the President, as we can see from provision from Article 132, Sub-Article 2. Constitution. That is right at the beginning of the folder which I handed to Your Honours this morning. Immediately after the index, there are some selected pages from the Constitution of Kenya. We're dealing here with the provisions of Article 132 and Sub-Article 2. The President shall nominate the National Assembly, appoint and may dismiss others, the Attorney General. Now, as I say, I cast no aspersions. I'm quite sure that the Attorney does, in fact, perform his statutory duties perfectly independently. I'm not making any complaint about his independence. But ultimately, he is appointed by and may be dismissed by the President. So when he spoke of the President fulfilling his duties by by the appointment of independent persons to carry out the specifics of compliance, himself as one of those persons, it has to be borne in mind that Mr. Kenyatta has the power, firstly, to appoint him, and secondly, perhaps more importantly, to dismiss him. There's just one other matter which I wish to deal with. I'm conscious of the time. Just before I do, perhaps I can ask what might be called a scheduling question. Your Honours mentioned, or Madam President, you mentioned, that we will... There's just one other matter which I wish to deal with. I'm conscious of the time. But I presentations that in order fully to understand the context, it's important who said what from an earlier stage. And at some stage, and if we're going to do it, it's going to have to be this afternoon, and I know that that was an unwelcome thought, but if we're going to do it, I would seek the opportunity briefly to take you through the correspondence, because it is extremely illuminating. But I say that as an aside. There's one other matter, substantive, that I want to refer to now on this subject. A little while ago, I think it was in fact in answer to one of his questions, the attorney dealt with the procedure to be followed for the taking of evidence. That was our article, the ICC article 93(1)(b). I'll just pause so that your honours can find the relevant. Your honours will recall that the attorney, as I understand it, draws a distinction. He hasn't been completely... He says some of these powers can only be exercised, such requests can only be made, if there is an order of the chamber, those which he characterised as judicial requests. Whereas others, he said, the prosecutor can make the request direct. I have to say, as an aside, I struggle to find any such distinction in this article or anywhere else, but that's his submission. And specifically, Your Honour was asking about 93(1)(b), the taking of evidence. And he gave the example. I think Your Honour said, would it be like this? And he said, no, not quite. It will to find any such distinction in this article or anywhere else, but that's his submission. And specifically, Your Honour was asking a request under Article 93(1)(b) would have to come from the court, would have to be from the chamber, by way of an order of the chamber. And it's been drawn to my attention that, in fact, that is inconsistent with the last time, I may be misspeaking, I don't know whether it was the last time, but an occasion when the prosecutor made precisely such a request. I handed a letter from the previous attorney, which is dated the 4th of October. This relates to a request made directly by the prosecutor without the intervention of the chamber, without any chamber order, transmitted directly to the attorney, Amos Waco, the Honourable Amos Waco, responded. And in responding, and I will be able to have copies of the letter produced over the as can see it, but in responding, the attorney simply said, the prosecutor has requested the government of Kenya to authorise and facilitate the interview of... So it's interviews, it's 93(1)(b) business we're dealing with. The attorney goes on to say, I am satisfied that the request relates to the investigation being conducted by the prosecutor, and I hereof give authority for the request to proceed. I kindly request you to appoint on a priority basis a judge of the High Court to take the evidence. So, at no stage back in 2010, when precisely such a request was made, was the government of Kenya, as represented by the then Attorney General, saying, no, no, only the court can ask us to do this. On the contrary, in a very brief letter, he was making apparent his ready compliance with the direct request of the prosecutor. It's a very clear indication, there are others, that the position currently occupied by the government of Kenya is not a consistent one. It's a late-coming one in an attempt to evade its responsibilities with the direct request of the prosecutor. It's a very clear indication, there are others, that the position...
Thank you very much. You will be given a chance to talk about when.
I'm very grateful.
We have 10 minutes before lunch break. I would like to ask defense team if defense has anything to say.
I do, Madam President, on the matter of late-coming arguments being relied upon by parties in these proceedings. It's my submission mission. In fact, contrary to the impression last week that the reason why the prosecution could not withdraw proceedings because of the failure of their case relied upon non-disclosure of financial records relevant to the case, to the prosecution by the government of Kenya, is in fact not a correct assertion. Time I have been able to review the correspondence between the parties, being the government of Kenya and the prosecution, in a file provided to me yesterday by Mr. Gumpert. And for my purposes, in relation to the situation concerning the state of the Kenyatta case, which is a discrete issue in relation to the generality of the application before the court, the issue that I have to make concerns, in fact, the absence of discrete issue in relation to the generality of the application before 2012, and the assertion made in court was that the request for assistance which was made was for Mr. Kenyatta's financial records. We suggest if he did indeed make such financial contributions, there would likely to be records of movement of funds at the relevant time. And last week we were told that this was the one pebble in relation to the case of the prosecutor that needed to be looked at. And in relation to the matter, it was given this importance to the issue that it could be highly suggestive of innocence or at least non-involvement in the way we have suggested, or alternatively there may be unexplained movement of large amounts of money. And despite the 4 years of this case, the impression was given that repeated requests had been made to the government of Kenya, specifying in accordance with the statute the grounds and reasons for wanting this evidence. I invite your honours to in fact turn to the second page of the request for assistance that forms the basis of this dispute, dated the 24th of April 2012. And you will see set out in paragraph 9 the various assistance relation in this dispute, dated the 24th of April 2012. And it is quite, as you review 9A, there is for the accounts to show the movements of funds. Simply not here. Paragraph 9A deals with lands. Paragraph 9B, companies. Paragraph 9C, income tax returns. And then we get to paragraph 9D. It specifies to identify any bank accounts held by the individual personally or through third parties, companies, on a present and historical basis going back to June 2007, and the current balance on those accounts. Just says specify or identify bank accounts, not the records of those accounts for January 2008, which is the matter that was raised before you last week, and the impression given that the case could not fail last week because there was an outstanding issue that had been prevented from being investigated. In fact, it was an issue that was never raised. If you go to paragraph 9E, the request concerns transactions by individuals or linked companies. It was an issue that was never raised. If you go to paragraph 9, F, Capital Markets Authority, Post Office Savings Bank account, identify them and give the current balance on those accounts. The list goes on. It is not the issue of the financial records of the accused and the matter of withdrawal of funds in relation to the activities alleged by the prosecution at all. Those grounds were never in this request, and the linking of this issue with the collapse of the case reflects exactly what I told the court last week, that this is being used as a cover to blame someone else for a case that has failed and evidence. And finding us drawn into these proceedings, issue dealing with in relation to my case, which was the issue of the termination of those proceedings, given the admission by the prosecutor of the lack of evidence and the offering of no evidence for the trial date of the 5th of February. And I raise this matter now because I've noticed some of the questions from your honours referring to financial records and the offering of no evidence for the trial date of the 5th of February. Within the dispute between the prosecutor and the government of Kenya. It is a case we were dealing with last week was an issue to the nation of the proceedings. Basis that was sought to bring and to provide an adjournment for the prosecutor in relation to that simply that had ever previously been raised. And I draw that to the attention of the court at this stage. Thank you.
Thank you very much. We need to take a lunch break for 90 minutes. So we rise now and come back to the same courtroom 2:30. The hearing is suspended.
All rise. We will obey. All rise. We will. Please be seated. We will just swap.
Good afternoon, and thank you very much for coming back to this courtroom. Before I give the floor to legal representative, I have one clarification which I'd like to seek from from Mr. Attorney General regarding the interpretation of Kenyan law, which I may repeating myself, and Mr. Attorney General has already responded. In that case, forgive me, but I need this specific clarification. Kenyan law, which I may repeating myself, and Mr. Attorney General always a court. In this case, this chamber. And is that so, for example, in case of bilateral mutual legal treaty, for requesting government, for example, if it is the mutual legal assistance treaty, Kenya and UK, in order to make a judicial request through that treaty, UK government a court order to that effect. The prosecution request.
President, I'm happy to answer your question. First, I want to clarify that we have in Kenya, as in many other, an independent mutual legal assistance act to mutual legal assistance across the board. Its provisions do not override where there is a specific treaty obligation. For example, we have a whole corpus of law on extradition. We have, let's say we have two sets of laws on extradition. One covering Commonwealth countries as a special category of countries, and another one covering the rest of the world. That law is a law of general application. Where there is another methodology specific to another treaty, that specific overrides the general. It is not a requirement that every mutual legal assistance request should be contained in a judicial order, because, as we have sought to demonstrate, every mutual legal assistance request should be.
I'm sorry to interrupt, but I'm talking about judicial request. In case that any country which you have this mutual legal assistance treaty, whenever this country requests assistance in getting a document, and if this request comes under the heading or comes under the category of judicial request, the requesting country always need court order or not?
Well, it depends to the discussion in the morning. It depends on the nature of the request. If we were to be requested by any government and surrender a person, that would have to be contained in a judicial order that we are enforcing. A prosecutor in a foreign country cannot tell us the crime of murder in London, please arrest in Nairobi Mr. XYZ and send him over to me. We cannot do that, and that can't be done. But we can receive service from the Serious Fraud Office, from any other competent authority, a request, for example, to confirm, are the following companies registered in the registry of the Republic of Kenya on companies as foreign British companies? And we don't need a court order, because that is a straightforward request that can be enforced outside a court order. So my answer, like it was in the morning, is we need to remind ourselves what is the character of the request. Some requests do not require any court order or any judicial intervention of any nature. Others must, by their very the morning, is we need to remind ourselves what is the character of the request. Some requests do.
Now I give the floor to representative of victims to address issues which we have been discussing.
Thank you, Madam President. The cooperation which is set out in the ICC's structure, insofar as it is relevant to today's proceedings, is set out in Part 9 of the statute, Chapter 11, Section 1 of the Rules of Procedure and Evidence, and Chapter 7, Section 1 of the Regulations of the Court. And in Kenya, that model is set out in the International Crimes Act. The model aims to reconcile three competing interests: state sovereignty and the deterrence of atrocity. Now, the model was agreed to by the states parties after very extensive negotiations, in which Kenya also participated, a co-author of that detailed and delicately balanced model of state cooperation. And I submit that there are four themes which run through that model: statute and the associated ICC instruments, or whether you look at the International Crimes Act. First, state parties must cooperate and must comply with requests for assistance from the ICC's prosecutor in its investigation and prosecution of crimes within the jurisdiction of the court. This is not an option. It is not a favour to the court, nor to the victims of the crimes charged. It is an obligation. Now, in a decision in the al-Bashir case concerning the failure of the Republic of Malawi to arrest Omar al-Bashir, at paragraph 46, Pre-Trial Chamber 1 said, "Indeed, it is the view of the Chamber. It is an obligation." Now, in a decision in the al-Bashir case concerning the failure of the Republic of Malawi or acting on its behalf, its parties are instruments for the enforcement of the use of the international community, unquote. Now, that arose in the context, of course, of Malawi failing to arrest al-Bashir, President al-Bashir of Sudan. I'd like to note in this context that failed to arrest Omar al-Bashir when he visited Kenya Constitution in 2000. This obligation appears in the statute in Articles 86 and 93, subsection 1, and appears in the International Crimes Act, sections 76, 77, and 104. The second theme is that states must comply with requests for assistance promptly. This concept of prompt compliance comes out particularly strongly in the International Crimes Act. The words which appear in that act are prompt, immediately, without delay, urgently. I refer to sections 26, 76, 84, 86, and 95 of the International Crimes Act. Some of those provisions relate to surrender of persons, some of them relate to access to evidence. That a state is expected to make a genuine effort to cooperate. If a state feels that it cannot meet the request for assistance, it must find, or at least explore, other ways to meet the request. That comes out in Article 93, subsection 3 and subsection 5 of the statute. It appears in sections 24, subsection 2, section 111 and section 112 of the International Crimes Act. And the fourth theme, which I submit appears, is that if there is a legal barrier to cooperation, the state party must consult with the court promptly and without delay. That appears in Article 93, subsection 3 and 97 of the, which I submit appears, is that if there is a legal barrier to cooperation, the state party must consult. I think a couple of times. The obligation is not on the to prosecute the non-compliance by the state. The obligation rests squarely on the state party to consult with the court. The difficulty in this case is certainly not with the enabling legislation. In many ways, I respectfully submit the International Crimes Act 2008 is a model for enabling legislation. The problem is that the Attorney General has failed to comply with its provisions. Now, I wish to go straight to what happens when receives a request. 3, subsection 1I, of records and documents. Turn to section 104 of the Act, as I mentioned this morning. If the request appears to fall under Article 93, subsection 1L, then the Attorney General must turn to section 108 of the Act. Now, whichever section the Attorney General turns to, or to put it another way, whichever section the request relates to, the discretion given to the Attorney General under the Act is very limited. He must satisfy himself of two things. First, the request relates to an investigation being conducted by the prosecutor or any proceedings before the ICC. And second, the document or record sought is or may be. That's the extent of the inquiry that he is expected to carry out, or indeed permitted to carry out, under sections 104 and 108 of the International Crimes Act. Now, one of the letters referred to by Mr. Gumpert, I believe, was dated the 6th of December 2012. And at page 2 of the prosecution's letter, the prosecution refers to an assertion made by the government of Kenya, in which the government said, now, one of the letters referred to by Mr. Gumpert, I believe, was dated the 6th of December 2012. And either Article 104 or 108, that assessment by the Attorney General is entirely irrelevant. Now, when satisfies himself of the two branches of the test that I just referred to, he shall forward the request to the appropriate Kenyan agency. He has no discretion to send it on. And when the agency receives it, without delay, it must use its best endeavours to comply with it. Follow-up duty set out in of the International Crimes Act. But I submit that the spirit of those sections, and indeed the entire Act, suggests that the Attorney General should be following up with the agencies that he sent the communication to say, well, how are you getting on? Have you found it? Expect to receive it? And do you have any legal problems which I should raise with the court? As far as I've seen, and I wish to emphasise I'm not privy to all of the correspondence, In fact, I'm only privy to that which I was provided yesterday, as was Mr. Kay. But I have not seen anything to suggest that the government's follow-up has been particularly impressive in the circumstances of the present proceedings. Now, in the Attorney General's submissions, both written and oral, there has been a suggestion, I understand, that incriminating relating to a Kenyan citizen cannot be disclosed to the ICC without the consent of that citizen. I won't repeat Mr. Gumpert's submissions, which he has alluded to, I believe. I fully support what the prosecution has already said in writing on this. But the argument is itself totally inconsistent with the International Crimes Act. Almost the entirety of sections 95 to 104 of that Act deal with providing evidence to the ICC where that evidence is located in Kenya. It includes search and seizure operations. There's no reference anywhere in the International Crimes Act to any obligation to obtain the consent of the suspect. Nor is there any reference to any obligation where that evidence is located in Kenya. It includes search and seizure operations. There's no reference anywhere in the International I believe your honours have already alluded. Privacy in most jurisdictions exists, and the right of law enforcement authorities to gather the evidence that they need to uphold the rule of law and to hold accountable those for crimes also. The right to privacy never trumps the latter of those rights. Clearly, sections 95 to 104 of the Act envisage the provision which will incriminate a citizen, as well as the provision of evidence which will exonerate a Kenyan citizen. Legal barriers to providing assistance to the ICC, which are expressly identified in the International Crimes Act, as far as are those in sections 109 and 110. Open to correction, I don't believe that the Attorney General has raised 109 or 110 as barriers in the present case. Let's turn now to the subject of consultation. As I've said earlier, the of a state party to consult with the court if a legal difficulty emerges when the trade is best to comply with an RFA runs through the International Crimes Act itself. It comes up time and again. See, for example, sections 24 subsection 1, comes up again section 24 subsection 2, section 44, section 45, section 54, section 114, section 115, section 156, section 157. These provisions concern a wide range of areas, including the surrender of a person, providing access to evidence, and concerns relating to state security. But the message is section 156, section 157. These provisions concern a wide range. Article 93 consultation process of December 2013. My submission, that is simply not in accordance with its obligation to consult promptly and without delay. That initiating consultation is itself a violation of both the Rome Statute and the International Act. In this morning's proceedings, there was some discussion on two issues. The first was whether the court order necessary to obtain access to evidence in Kenya must be an ICC court order or whether it can be a domestic court order. And the second point, which I believe has arisen both in written and in oral submissions, is whether it is the duty of the Attorney General to seek a court order or whether it is the duty of the prosecutor to seek a court order. And I'd like to identify a few submissions which might assist on this point. The International Crimes Act in sections 96, subsection 2, section 107, and in the second schedule to the Act at sections 3, 8, 17, and 23 subsections, repeated reference to situations where a court order is sought in Kenya with the authorization of the Attorney General. In some of those, in at least one, it's sought from a magistrate. In others, it's sought from the High Court of Kenya. In at least 3 of those provisions, as I recall, it is a police officer who will request the court order, having been authorized to do so by the Attorney General. So the clear model which appears in the International Crimes Act itself is that if a court order is necessary, it is a domestic court order, and it is essentially the duty of the Attorney General to make the arrangements for someone to go to court and to request that order. Which appears in the International Crimes Act itself is that if a court order is necessary, it is a domestic court order. Nor do I see any reference in the International Crimes that the prosecutor provide an order from a trial chamber in order to gain access to evidence in Kenya. I'd like to pause for a moment here. What is it in the requested documents? And I'm not focusing just on the documents which are the subject of today's Article 87.7 application. All of the documents referred to in the prosecution's annex of the 31st 2014. What is it in them that the government is so worried about? I want your honours to see them. Why don't they want the prosecutor to obtain them? Nothing wrong in there. Why don't they disclose them? Now, I also would like to briefly point out the Attorney General and the President are obliged under the Constitution to uphold the constitutional rights of all Kenyans. That appears in Articles 131 and 148 of the Constitution. Why, I ask rhetorically, is the Attorney General so firm and unyielding in his defence of the 3 Kenyans on trial before this court, and, as far as we can tell, wholly uninterested in the rights of the tens of thousands of Kenyan citizens who are the victims of the crimes of this case, and who have an equal right to see the rule of law upheld in Kenya, and that rule of law includes the international of the tens of thousands of Kenyan citizens who are the victims of the crimes of this case, which, as the Attorney General pointed out, has been domesticated. I'd now like to turn to a couple of arguments made by the Attorney General in his filing dated the 20th of December 2013. It's file 7. I'll run through these points fairly quickly. To the public officer ethics, and has criticised the prosecution in part because the prosecution has identified the correct commission that it sought the records referred to at paragraph 10 of the request's letter. Background might be of assistance here. The Act, as I understand it, focuses on the conduct and performance of public officers and seeks to improve service delivery to the public. The Act defines a public officer. It includes employees of the government or any department, service or undertaking of the government, the National Assembly or the Parliamentary Service or a local authority. And it requires those individuals to provide an annual declaration of income, assets, liabilities, etc. Now, a small family of different commissions which are covered and identified under Section 3 of the Act. It should be very easy for members of the Attorney General's staff to identify which commission applies to Mr. Ruto, which commission applies to Mr. Kenyatta, and which one applies or applied to Mr. Muthaura. Mr. Sang was not a part of this, I understand. Yet the Attorney General has nevertheless thrown the duty to identify the commission back on the prosecution. And yet he's taken the position today, and indeed he took the position in a filing 1184 in the Ruto and Sang case of the 10th of February 2014 at paragraph 23. The Attorney General said, and indeed he took the position in a filing 1184 in the Ruto and the power to interpret Kenya's national law, and he's maintained that position here today. The Attorney General cannot simultaneously argue that the prosecution has failed to identify the commission to which a request should have been sent, while saying that the prosecution basically has no standing whatsoever to interpret the law of Kenya. The of the 20th of December 2013 refer to a Civil Aviation Act which is no longer in force. Specifically, the government referred to Civil Aviation Act, Chapter 3.9. That act was repealed by the Civil Aviation Act number 21 of 2013. Indeed, at Section 83 of the 2013 Act, a side note expressly notes that Act 394 has been repealed. It is the 2013 Act was assented to on the 14th of January 2013 and entered force on the 25th of January 2013 with none of the confidentiality clauses of the earlier Act. The 2013 Act does contain one clause which I'll read into the record to save us looking it up. Quote, aviation safety and security information obtained, gathered, voluntarily or otherwise given to the authority under this Act or regulations made thereunder shall not be put to any inappropriate use, unquote. Now, it's clearly the appropriateness or otherwise that guides the authority in deciding whether to share information. And clearly, information relating to crimes committed against thousands of Kenyan citizens is certainly the kind of information which is put to appropriate use and should be disclosed under the new Act. I want to turn briefly to some aspects of the Constitution. There have been to crimes committed against thousands of Kenyan citizens is certainly the kind of information which is and dismisses the Attorney General. I'm slowing down for the benefit of the transcriber. That is Section 132, Section 2. Under Section 152, subsection 1C, the Attorney General is a member of the Cabinet. Under Section 40, subsection 2F, the Attorney General is a member of the National Security Council. Elsewhere in the Constitution, we see that the President chairs Cabinet meetings. The President appoints all of the Cabinet secretaries, that is to say, he appoints the Minister for Finance, he appoints the Minister for Foreign Affairs, for Land, for Education, for Health, all of the ministries which we would find in most countries. It's clear, therefore, it's right at the heart of government. It is also inconceivable that cooperation with the International Criminal Court by the government of Kenya was not discussed in cabinet meetings over the past year in particular, since Mr. Kenyatta took office as president. Under the International Crimes Act, it is principally the Attorney General who is responsible for coordinating the compliance of requests for assistance from this court. And we've referred earlier to the fact that under the Constitution, it is the President who is obliged to ensure that the Republic complies with its international obligations, and the President has the power to appoint and dismiss the Attorney General. And we've referred earlier to the fact that under the Constitution, it is the President who is obliged to ensure violate on a daily basis every international agreement to which Kenya is a party. The Vienna Convention relating to diplomats, for example, the African Union, the Charter of the United Nations, for the suppression of unlawful acts against the safety of civil aviation, hostage-taking conventions, terrorism-related conventions. If we were to have what I might describe as a rogue prosecutor going into work day in, day out, the obligations of Kenya, is the President expected simply to sit there and watch? Is he expected simply to let this rogue Attorney General this job of violating the country's obligations? Of course not. The President must then step in and dismiss the Attorney General. So it is the position, in my respectful submission, that the President, as the Constitution sets out, is the person ultimately responsible for ensuring that the Republic complies with its international obligations, and any failure by the Republic is ultimately the responsibility of the President. Your Honours, I know you're already familiar, because His Honour Judge Henderson has already referred to the extensive nature.
Mr. Gaynor, I'm sorry to interrupt you. We have to finish this status conference today.
Yes.
Because tomorrow there will be another status conference for another case. So I appreciate if you could just not speed up, but to limit your submission to the most important parts.
Certainly. Just two more points, and we'll be responding in writing to the government submissions of yesterday. But the President of Kenya is not a ceremonial office. It's nothing like the President of Germany or the President of Ireland. This is a President with very heavy executive powers. Those are set. Just two more points, and we'll be responding in writing to the government submissions of yesterday. But the President of Kenya is not a ceremonial office in the Constitution. The final point, and I'd like quickly to update Your Honours on something that I referred to the submissions in the last status conference. It's relevant to the question of non-prosecution. I told Your Honours that we were waiting for a report from the multi-agency task force. Now, the Director of Public Prosecutions confirmed on the very same day as that status conference that the multi-agency task force has a review of the 4,000 plus files, and that not one prosecutable. That ironically was in Naivasha on the 5th of February 2014. For the record, I'll simply read what he said. My submissions, thank you. The Director said the 4,000 plus files that they have reviewed, none of them are executable, none of them, and that is a fact, a sad and painful fact, has been found to contain sufficient evidence to be prosecuted, whether as international crimes or otherwise. What I'm saying this, the sad and painful truth, we must face it, is that at present there are no cases arising out of the PEV that can be prosecuted before the ICD. I'll end that quote. And I would very much encourage Your Honours, when considering the prosecution's application, to focus not only on the specific request which the prosecution has chosen as a specimen charge of a litany of non-cooperation, but also to take into account the entirety of what has happened in this case, as I explained on the 5th of February in the Status Conference, as well as, for example, the filings by the victims dated the 6th of May 2013, filing 731, and also, very importantly, annex to the prosecution's submission of the 31st of January 2014. Thank you very much, Madam President.
Thank you very much. Now,
filing 731, and also, very importantly, annex to the prosecution's submission.
Madam President, the procedure must, of course, be entirely a matter for you. Ultimately, this is an application, and in normal circumstances, in my submission, in these effectively civil proceedings, we're not prosecuting anybody here, we're asking for an order. The court will make a balance of probabilities determining whether there has or has not been a failure of compliance. In those circumstances, those asking for the order would normally have the last. I would invite you to consider whether, in fact, the sequence of proceedings which you have just outlined should be reversed. If it doesn't find favour with you, I'm ready to make 4 separate points now.
well, I think you asked the chamber for the time to go through all those exchanges, and I think it's better if you proceed with.
I take no further point. I raise the matter. If Your Honour's against me, in the end, who speaks when probably doesn't matter very much. It's the quality of what is said, I'm sure, in the end, which will matter.
Well, I think we can come back to this issue later and see what will happen. Just a moment, please. Please proceed.
I'm grateful, and I'm sorry I need to seek a further clarification. There are 4 matters that I need to say to Your Honours, to submit to Your Honours at some stage. The first is just to clarify the letter which I referred to, but have now provided in written form. The second is the matter of who said what and when, which we referred to before lunch. The third is a brief response to the point which my learned friend Mr. Kay made, which centred on the word identify in the request, in written form. The second is the matter of who said what and when, which we referred to before lunch. May I address all of those 4 now, or would you wish me to restrict the chronology of who said what when?
Considering that we have 15 minutes, I think you should address 4 points at the same time. And how many minutes do you need?
I think I can manage in 10.
Okay, that's good.
Let me deal firstly with the chronology, because that joins up. I've dealt with the latter half of the chronology in responding. So let me start, and may I refer you to the binder which I provided, and take you immediately to tab number 3. JA45, the request for information, is served on the 24th of April. This response comes on the 14th of June, 6 weeks later, and it's a blanking response. We need more details. Another 6 weeks passes until we get to the item which is at tab 4. We're now on the 25th of July, or at least there is a meeting on that date. This is an email, or a copy of part of an email, on the 31st of July. And it appears from that there has been confusion in the mind of the Attorney General about whether it is this request or some other request from the registry. Do I understand I'm going too fast? No? Sorry. So it seems finally now, 3 months after the event, that things are clear in the Attorney's mind. The next item is the loose item. This was my error. I hope I provided it. I know I provided it this morning. I hope Your Honour still have it. It's a letter of the 7th of August. This was my error in not including it in the months after the event, that things are clear in the Attorney's mind. The next item is the loose item. This was my error. Some 2 weeks later, for the first time addressing substantially the request of the prosecution. What do they say? We can't deal with this. There isn't a court order. On the contrary, request for financial information, transmitted your request to the Ministry of Finance. So any reasonable reader would understand things are, albeit a little slowly, going ahead. The next item, which is at tab 5, the prosecutor writes back, and, as he says, the slow pace of processing these requests is a source of frustration. Your Honours may think not surprising. 18th of September at tab 6, follow-up for the above matters, and your letter dated the 11th of September. The relevant part is on the second page. Request for financial information for, amongst others, Uhuru Kenyatta. We hereby attach the request sent to the relevant authorities. So again, what the Kenyan government is saying, yes, it's fine, it's just taking a little time, we've sent off the requests. Tab 7, 29th of October, more time passing by. And again, this is now from the prosecutor herself. Please, hurry up. Time is running out. And the reference is made to the deadlines which have been imposed not by the prosecutor but by the trial chamber for the submission of evidence. The next item at tab 8. The Attorney General writes back on the 7th of November. It looks here as though he is for the first submission of evidence. The next item at tab 8. K, not included in today. It's an order for freezing of property. And what he doesn't mention at this stage is the 17 headings of financial records. And the prosecutor takes him up on that at tab 9 and spells it out. We need to know what you're doing about the financial records. And that takes me to the point where I last began. So, the sequence makes it plain that at no stage, even as late as June of last year, and that is at tab number 18, I won't take you to it now, the recognising that the prosecutor had the right to make these requests. That's point number 1. Point number 2, Your Honours have the letter now in writing. It was a request to interview police officers. It was classically the kind of request which the attorney has called a request of a judicial character, which he has told you would have to be, firstly, coming from this chamber rather than from the prosecutor, and then being processed in the manner he's described. And yet we see clearly here that that is not the view the government of Kenya took in relation to interviews with those police officers, which, I may say, have never happened, because there remains an injunction in Kenya, an interlocutory injunction now nearly 3 years old, which the government has never challenged. Those interviews, crucial interviews with police officers, have never taken place. Point 3, Mr. Kay's point. As a matter strictly of grammar and etymology, I immediately concede that using the word identify rather than copy and produce was probably the point. As a matter strictly of grammar and etymology, a sensible proposition. The process assistance would be an ongoing and collaborative one. Yes, the Kenyan government would say, he's got these numbers, this is the current balance. That's very interesting. Please can we see the statements for this one, that one and the other one? But we didn't even, to use the baseball expression, get past first base here. We didn't even have the documents identified to us. The idea of in some way slightly disingenuous or misleading the court, it doesn't stand up. It is quite plain that what the prosecutor wanted was access to Mr. Kenyatta's phone records and various financial records, and we've never got them. And point 4 is a matter raised by Your Honours. Am I out of time? I hope I've got a couple of minutes left. Madam President, you supposed, you made no indication that this was the way the bench was thinking or the bench would ultimately resolve it, and indeed, I dare say you haven't decided yet, that one possible solution to the government of Kenya's first proposition, well, the prosecutor doesn't have the power to do this, it has to come from the chamber, would be for the chamber to make a parallel order so that that argument by the government of Kenya would then fall away. Madam, that might be a rather pragmatic solution to disposing of that argument. And ultimately, it will be for Your Honours to decide whether to take that course. But it shouldn't be that way. There's an important matter of principle here which is much wider than just the proceedings in this case. It strikes at the root of the prosecutor's powers. The essence of what the prosecutor can do by way of investigations is set out in Article 93(1). That is plainly intended to cover the gamut of all of the inquiries which could reasonably be made of a state's party. Please help us in this way, that way, the other way, and then the catch-all at the end. If there's anything else, the state's party has to do that as well. It's vital that there is clarity. For the last 10 years, no state, including Kenya, has been made of a state's party. Please help us in this way, that way, the other way, and then the catch-all at the end. If there's anything else, does not have the power to make those requests. First time, that radical and novel suggestion, if it is a correct suggestion, it will transform the way in which the prosecution duties under the Rome Statute. It will dramatically increase the prosecutor's powers. Every time the prosecution wants to do anything which will require government assistance, we'd have to come to the court to do it. That's never been understood to be the way in which the prosecutor has to operate. And so it is vital, I respectfully submit, that whatever course the takes with regard to ensuring that these items requested are eventually provided, and that's extremely important in itself, that the other important matter is also addressed, the matter of principle. There needs to be a declaration by the court that the prosecutor is indeed entitled to make such requests, that the prosecutor is indeed included within the word "the court" in the preamble to Article 93(1). And I respectfully submit that whatever ruling Your Honours make addresses that issue, and I, of course, invite you to find that the prosecutor does indeed have those powers. Thank you very much.
Thank you very much, prosecution. Now I invite representative of the Republic of Kenya if they want to make any
Yes,
response.
Madam President, I thank you for the occasion to respond very briefly to the observations that have been made. And I would like to start with the observation that was made regarding the responsibility of the President of the Republic of Kenya in regard to the enforcement of international treaties. I would have thought myself that I would like to start with the observation that was made regarding the responsibility of the organization. If that had not been the case, the Constitution would have said that the President shall enforce the treaties himself. It would be an absurdity. The Constitution places one obligation in this respect, and it is in Section 100, Article 132, (1) 3, and it is to submit a report for debate to the National Assembly on the progress made in fulfilling the international obligations of the Republic. Fulfillment of international obligations by treaty on a day-to-day basis is entrusted to officers appointed for that purpose. The only obligation the President has is to report annually to the National Assembly, a supervising body. And I rest that argument and say no more. And then I will to much heavy weather was made of an argument that the Attorney General is not an independent office and the occupant is not an independent officer. I think the research of Mr. Gaynor would have shown that there is a statute known as the Office of the Attorney General's Act, which states in the clearest possible language in Section 16, subsection 5, that in the exercise of the powers and performance of the office, the Attorney General shall not be under the direction or control of any other person or authority. Maybe for the completeness of the record, it should be shown that. Now, as to whether the individual Attorney General exercises independence, I do not wish to say anything that may of the record. It should be shown that. Now, as to whether the individual Attorney General exercises independence, who would want to this by violating the Constitution and the law to which the person has sworn oath to protect. And I say no more as to that. The distinction between judicial process and a non-judicial process is not only a commonsensical one. Under Article 93, it is also a legal one. It is inconceivable, in my judgment, that any court would countenance a situation where a person can be arrested and removed from the territory of a sovereign state on the instigation of a letter by a prosecutor. It would be inconceivable. If the rule of law means anything, it would mean that every decision of that nature would be subjected to judicial review. At any rate, if that is not the law in any other country, it is certainly the law in Kenya. Let me come to an issue raised relating to an opinion that has been placed before the court that has been attributed to my learned predecessor, the Honorable Amos Wako, and that is dated 4th of October 2010. Two things are important here, Your Honors. Number one, on 4th October 2010, there was not a prosecution relating to Kenya. There was an investigation. The distinction between an investigation and a prosecution, I do not think requires any elaboration. That numerous prosecutions do not result in a prosecution, I do not need to elaborate upon. That the minute you have a defendant or an accused person or a suspect, the character of the investigation changes, again, does not need any elaboration. That in most jurisdictions, that the minute you have a defendant or an accused person or a suspect, that I am investigating the offense of murder and everything you tell me will and can be used against you, again, whatsoever. Number two, this letter is written during a transition. New constitution has come into force. Director of public prosecution has not been appointed. Mr. Amos Wako is acting as the acting director of public prosecutions, dealing simultaneously with a conflict that does not face us today, which I have demonstrated at. I think the less I say about that, the better. Save to add this. Mr. Wako himself says, I am authorizing you to facilitate an interview. An interview. I don't know whether that is the language that the learned prosecutor suggests is to be found in Article 93. I have seen no reference to an interview in Article 93. Finally, it is a matter of record, the honorable judges, that the Kenya government, as soon as Mr. Wako wrote this letter, and as soon as the Chief Justice constituted a bench, the Kenya government ran into serious constitutional and legal questions arising out of the letter. And that is how the High Court, as a constitutional court, stopped this process by Mr. Wako and said this process was illegal and unconstitutional. I think that it is the obligation of the prosecutor to, at the very least, place those facts before this honorable court. I associate myself and unconstitutional. I think that it is the obligation of the prosecutor to, at the very least, glossing over the question of what is it they asked the Attorney General to do, financial records of Mr. Kenyatta. The document speaks for itself, honorable judges. The document said the OTP requests that the competent authorities of the Republic of Kenya should financial profiles. I have not come across that language in the statute or the rules or anywhere else. Full financial profiles of so and so and so and so and so and so. Now, unless the prosecution, because that is their prerogative and privilege, if they wish to serve a different request, that would be their privilege. They never served the request that they now claim before this court was never honored. There was never such a request. And I say no more about that. Mr. Gaynor is perfectly entitled to the very strong submission that he makes about of the victims. And I want to place this on record, Madam President, because this is the position of the Kenya government and it has never changed over the last 6 years. The tragic events of 2007-2008 were very, very serious, admitted by all to have been so, and the Kenya government and the Kenya people committed themselves to ensuring that this would never happen again. And we had a peaceful election a year ago, the only evidence that you require of that. The Kenya government has spent, and the Kenya government and the Kenya people committed themselves to ensuring that this would never happen again. About the treatment of its own victims of an unfortunate circumstance like this, because this is the very fundamental duty of the sovereign state to its citizens. The material is on record. We continue to do that, and I can assure you we'll always continue to do that because that is our duty. Victims, about the victims, and anybody who has been to Kenya, and I challenge anybody who has been to Kenya and gone to contact the groups that have been working in this area will confirm that a lot has been done. If more work remains to be done, we are committed to that work. But it would be a real absurdity to claim that the government of the Republic of Kenya has been insensitive or uncaring or unconcerned. It was said of my person as Attorney General that I have been firm and unyielding in favor of the accused, but unyielding in favor of the victims. I do not know whether I should respond to that. I do not know whether it was said in jest. I do not know whether it was intended as part of the serious material that the court should take into account. Let me say this, however. My job is to defend the rule of law. If in this court there is a proper defendant, properly presented to the court with the threshold evidence required by law, with request processed in accordance with the statute and the law, I shall comply. In this court, there is a proper defendant, properly presented to the court with the threshold. You have an International Crimes Act. Forget all that. That because there were victims involved in this and tragic, do what we are telling you. The existence of a body of victims is enough justification for a disregard of international law, a disregard of constitutional law, and a disregard of other law. For my part, to believe that that is to be considered a serious legal proposition. Mr. Gaynor also says that in his own judgment, it is inconceivable that the Cabinet of the Republic of Kenya could not, over the last year, have discussed the collaboration or cooperation of the ICC and of the Kenya government. I do not know his sources of information. I do not know whether he's privy to cabinet papers or cabinet minutes. But I have placed before you a signed statement in which I have controverted the possibility of that issue for reasons that are not far-fetched. The position in Kenya is unique. I don't think that needs any repetition. There has not been, and there is unlikely to be any reason for this case to be discussed as a cabinet matter, because the case and the process is being handled. There has not been, and there is unlikely to be any reason, and the process is being handled by independent office holders that cannot be directed by cabinet, require the direction of cabinet. Finally, there was an argument relating to DPP she should do or not do. Again, I dealt with this in the morning. The DPP is an independent office. But let me make because half-truth is repeated many times, it wears the garments of truth. The cases that were reported in the critical phase of 2007-2008 were cases reported in a period of turmoil. Persons were on the move, communities were on the move for several weeks and sometimes months during the interim. Several police stations, and the DPP has explained this ad nauseum, several police stations received a single complaint: my house was set on fire. Immediately after the complaint, or soon thereafter, that family or that community would move to a place they considered themselves safe. When all these files were put together, including files of sexual assault and other files, they were actually not 4,000, they were 6,500 and something. And we shared that with the prosecution. The prosecution came to my office. I understand that the prosecutor in this court is presently probably new to the brief. The prosecutor's office came. We sat in my office. We went through the files with the task force. We availed all these files for inspection. That it can now be claimed that this candidness and this openness by the Kenya government was without factual basis, then the prosecution is in a position to say, when we reviewed your files, unlike what you say, we found that 3,000 of them had evidence. They don't say that. They couldn't possibly say that by the Kenya government was without factual basis. Then the prosecution is in a position to say, when we review, that must lie between the applicant of this matter and the respondents to the matter. What I can tell you for sure is that if an application, a proper application for an order was to be made, we would ourselves require to be enjoined so that we could, at the earliest possible opportunity, guide the court on the nature of the processes that would be of assistance. And as I have said earlier before we broke for lunch, not a process that can be assumed would take a week or 2 weeks or a month or 6 months or a year. It would be an indefinite process because of the independence of the institutions that we have talked about. Finally, as my last comment to you, honorable judges, in thanking you for giving the Kenya government an opportunity to come and ventilate this issue, I want to suggest with tremendous respect that when you have looked evidence on the record and considered all the submissions that we have made, you will find that there isn't in the history of this court any situation country that has ever done what Kenya has done. There is no situation country whatsoever where this has ever happened. We take it is our constitutional obligation. And maybe I can say this before I sit down. Two successful governments of the Republic of Kenya have been urged by the National Assembly in an overwhelming resolution, not once but twice, to discuss. Two successful governments of the Republic of Kenya have been afternoon. I do not think that that is what the prosecutor suggests is the experience that the court had in a that I shall not name because officers of this court have been arrested and held incommunicado in several situation countries or at the airport. What has happened is the prosecutor has wanted to come. He has received state security, including paratroopers, to escort him throughout the country. Is that a country to be reprimanded? Is that a country looked? Or is that a country to be recognized as a model of how this court should work with situation countries? I leave it to your good judgment, but I thank you.
Thank you very much, Mr. Attorney General. The Chamber has a couple of questions to both Kenyan government and prosecution. The first question is the question of requirement of consultation as referenced in Article 93.3 and 97 of the Roma Statute, which, as Mr. Gaynor pointed out, is mirrored in Article 24 of the Kenyan International Crimes Act. The prosecution also pointed out numerous exchanges between the prosecution and the Kenyan government. We would like both the prosecution and the government of Kenya to address whether or not they consider it correct to state that so far no consultations within the meaning of those provisions have taken place. Prosecution and the government of Kenya to address whether or not they consider it correct in paragraph 29 that they are taking this opportunity to initiate consultations. So in short, in your view, this consultation as provided in Article 93.3 and has already started or not? Prosecution first, please.
Your Honours, the purpose of the consultation, as I understand, is where the state, Kenya in this case, finds that there is a fundamental legal principle of general application, I quote from the statute, which is preventing it from complying with the request for assistance. Well, you've heard my submissions on whether there is or isn't, so I won't belabor that point. But I would say the applicability of this fails right from the start. This isn't some fundamental legal principle which is preventing cooperation. And I'm wrong about that. The next thing is that there must be prompt consultation to try to resolve the matter. Well, even now, as Your Honour points out about consultation at the very last gasp, it isn't talking about consultation to resolve the problem, to get over this hurdle of domestic difficulty or the inability of the prosecutor to make such requests. It's saying flatly, you can't do this. You, the prosecutor, haven't got the power. That's not consultation, it is confrontation. So the answer to Your Honour's or the inability of the prosecutor to make such requests, it's saying flatly, you can't do this. Meaningful sense.
Thank you very much. Can Mr. this question? And I'd like to remind you that under those articles, it is for the requested state to consultations. Mr. Attorney General, please.
I want to repeat, Madam President, as we are concerned, the clear requirements of Article 93 are that state parties shall, in accordance with the provisions of this part and under procedures of national law, we have been invited over and over and over again to reference to procedures of national law and to deliver ourselves to interpretation of what this particular part of the treaty means as interpreted by the prosecution. The prosecution says, a letter that says, we disagree with your reading of Article 93, and we disagree that it can yield the sort of outcome that you are suggesting. We have just been told a few minutes ago that that is not a consultation, that is a confrontation. So when we disagree that it can yield the sort of outcome that you are suggesting, what would be the necessity of domesticating the Rome Statute? The prosecutor is right, then what the prosecutor is saying, forget any other law whatsoever. Rome Statute, as interpreted by the prosecutor, because the prosecutor is part of the court, is binding on you as transmitted in the request document. If you question anything in the request document, you have started a process of non-cooperation. I want to respectfully suggest to you, honorable judges, that an interpretation of that nature would create an absurdity. It would mean, therefore, that withstanding one of the most venerated traditions of international law, recognizing the distinction between the monist and dualist traditions, would have, by the single stroke of the pen of the ICC prosecutor, been resolved forever in favor of a reading of international law that says, if you sign a treaty...
Mr. Attorney General, yeah. I'm sorry to interrupt. My question was quite simple. In your view, has consultation provided in Article 93.3 and 97 of Roma Statute has been initiated or not. And I presume from your previous written filing that your government view is that this consultation has not been initiated.
A formal consultative process has never been commenced at the instigation of either party. However, the nature of the exchanges between the parties, very elaborate set out by the prosecutor, shows that the parties had an open and candid discussion, and we ourselves of either party. However, the nature of the exchanges between the parties, very elaborate, we ourselves take the view that the prosecutor was entitled to take the position of law that he took, a mistaken and misguided interpretation of the treaty and of Kenyan law. But that he was entitled to do that, we cannot question that at all. That he can be entitled to interpret our own law is surprising to us.
Thank you very much. The second question for prosecution. You said you are not aware, you have not been aware of the detailed legal arguments of the Kenyan government up until very late stage, but still couldn't have seized the chamber this timing at a little bit earlier stage.
Well, if I were to say anything other than yes, I would plainly be lying. We could have. And looking back now, with hindsight, perhaps it would have been better if we had. But Your Honours will see from the correspondence that the Kenyan government was at no stage expressing the position that there was a complete bar because the prosecutor wasn't entitled to make this request. Indeed, in a rather tantalizing fashion, when it was, when its feet were held to the fire, when it was actually required to address the financial and telephone records which we're talking of, its frequent response was, if I can use the colloquial, the check's in the post. We're working on it. Even as late as June, as we see from their filing telephone records which we're talking of, its frequent response was, if I can use the colloquial, the check's in the post. It was publicly saying they're not doing what they ought to. But they weren't saying, no, you don't have the entitlement. Your Honour will recall that the trial was slated to start in July, and it was perhaps not unreasonable that the prosecutor was concentrating on the evidence it did have, had failed to obtain through non-cooperation. And indeed, when the trial date was adjourned until November, similarly, the prosecution, for better or worse, with hindsight, was preparing for a trial on the basis of the evidence it had. It was when that trial date was adjourned, and I won't give Your Honours the details of the internal consultation, that it was decided that this motion, which had been long considered, now had to be pursued. So the short answer to Your Honour's question is yes, of course it could have been, and perhaps in hindsight it would. But it can't be right for a matter like this to be determined on the basis of the prosecution having, with hindsight, acted a few months later than it might have done, when the real problem here is not those few months, but the 22 months which have elapsed since the prosecution uttered this perfectly valid request, and during which time the government of Kenya has responded.
Thank you very much. And I'm glad to report to you.
Respond to that very briefly, please.
I'll give the floor after I speak. And I am glad to report to you that interpreters and court reporters and courtroom staff very kindly give us 30 more minutes, so we can sit here up until 4:30. Although I believe that we don't need 30 minutes more. Prosecutor, I think you finished.
Yes, I have. I was just going to thank the court staff for making that time available, although, like you, I sincerely hope that we're not going to eat.
We can sit here up until 4:30, although I believe that we don't need 30 minutes more.
Because the before this court, as we understand it, is that the case now pending before this court cannot proceed because there is evidence in the possession of the Kenya government that has not been surrendered to by the Kenya government over the last 1 year or so. Reference was made to a communication in which I had previously expressed surprise by this contention, and I need to explain myself in that regard. Judges will remember that when Kenya became a situation country and inquiry was opened of this court, and I have made extensive references to media coverage of his comments in public, he said over and over again, we have overwhelming, irrefutable evidence to prove, and he made his claim. When the confirmation hearings were held in this court, again, the prosecutor over and over and over again, as a matter of public record, said, we have overwhelming evidence in these cases that will prove these cases beyond reasonable doubt. This court, in its wisdom, and despite the dissent of one member of the court, decided that it had seen the evidence of the level that it required to see. That is the prerogative of the court. That is the discretion of the court. When the trial dates were taken, my member of the court decided that it had seen the evidence of the level that it required to see. Ready evidence is
Mr. Attorney General, I'm sorry to interrupt, but let's limit the issue before us, which is
let me now come to the issue.
Into the details of the case itself.
Okay, let me come to why I was telling part of the background. I wanted to demonstrate to you, Your Honors, that the prosecution has been changing its narrative continuously throughout this case. And the Kenya government merely became a bogeyman in this case very, very. That was never the narrative. There was never a narrative that this case has any difficulty occasioned by the Kenya government that would stop the case from going to trial. And therefore, as you consider this question of whether there ought or there can be or there has been any consultation, you must appreciate that the background is such that the facts demonstrate that the prosecution has never been interested in any consultation beyond asserting its right, consistently saying, we have already told you the law as we know it, now comply with it. I would therefore like to end by saying that in the view of the Kenya government, we have provided all the material that did not require under Kenya's domestic law for any special procedures to be invoked. And we have declined, and my own submissions, Madam President, will show this. We received over 40 requests that did not require under Kenya's domestic law for any special procedures to be invoked. Therefore, considering 40 requests, you are obstructionist, you are uncooperative, you are stalling, because you have raised a question about two issues. Cannot be it cannot be supported by the truth. So we urge you then to consider everything we have placed before you and to find that we, like you did before when we came to you to be joined amicus, you made a finding that said the Kenya government should not in the future be the subject of adverse commentary in proceedings not availed to it so that it can respond to those adverse comments. We urge you to make the same finding now, that we have demonstrated that we cooperated, we gave everything that was not contentious, and where there was contestation, we gave good legal explanations, and that only this tribunal or a judicial tribunal can override our interpretation of the law. Thank you.
Thank you very much. And please be assured that this chamber will make any findings and any decision after carefully considering all the submissions from all the parties and participants. Judge Freeman has a question.
I have one additional question to defense. Mr. Kay, today we have listened extensively submissions of both government of Kenya represented by Mr. Muigui and from prosecution as well. But I still miss one thing, that is, position of your client. But if I'm saying position of your client, I don't mean position of Mr. Kenyatta as a president, because position of represented by Mr. Muigui and from prosecution as well. But I still miss one thing, that is
yes, Your Honour. Any request for President Kenyatta in relation to his defence in these proceedings come to me, not to him. I'm his legal advisor, and I may or may not decide to exercise my defence rights, which this court must respect and has an obligation to respect. So decisions concerning the trial are decisions that I make in a broader tactical understanding this case is about. I've never had any doubt of the falsity of the allegations. You saw our filing, the number of times we pointed this out in correspondence, verbally before the courts, and we specifically pointed to the issues that have led of this case against Mr. Kenyatta. Witness 11, witness 12. We were met, may I say, with unremitted arrogance in respect of our observations. We were delivering up tapes, interviews. We pointed out to the court that the man, witness 12, was a congenital liar, that witness 4 was a congenital liar. We were able to piece together the fabric that demonstrated those lies. No one listened to us. It's only when we come to the collapse of the case on the eve of trial that these issues were being raised as against us. I pointed out in the correspondence between the government of Kenya and the prosecution on the eve of trial that these issues were being raised as against us. And in fact, the evidence that they had been seeking was nothing to do with the issue brought before this court on the occasion of the status conference. In relation to Mr. Kenyatta's position, I point out to the court another precedent before this argument and exchange between the government of Kenya and the prosecution commenced long before he was elected president. And in fact, it barely rumbled after he was elected president. It only became an issue upon the collapse of the case. And may I point out as well, two sets of proceedings, two separate sides that are within the framework of this correspondence only concern Mr. Kenyatta. It concerns the accused in the trial of Kenya 1. All those arguments were happening before he became president. And so in the circumstances, at this stage, laying or trying to impute or say we are responsible for it, without a shred of evidence in support, is unfair and not right. And it's trying to deprive him of his just right at this stage, which is the termination of the proceedings because the case has been found to have been false. That's a very important matter at this stage, and why, which is the termination of the proceedings because the case has been found to have been concerned about us dragged into this dispute issues that we have never been a part of. In fact, last week I thought the request for the financial records did concern post-election violence and withdrawals of cash. And then when I see evidence and realise it wasn't, it reinforced my submission of last week that this was a very convenient argument for the prosecutor to seize upon as an excuse to pass blame for their find credible witnesses, honest witnesses, and ignoring repeated warnings from the defence. We have given much disclosure in this case. We invited the prosecution, without any knowledge about mention of cell site in these letters, to join as co-plaintiffs in proceedings in the High Court under Kenyan legal procedures, because we considered how this should be done in relation to the proceedings. In fact, the prosecutor did not want to join us as co-plaintiff. They issued a letter in support of the justice of our application. So in many respects, they are the architects of their own problems here, and seizing upon areas of evidence that they say now are important to the issue, in fact, I would submit, show that in their own minds, they were not committed to the evidence in this case. They were of evidence that they say now are important to the issue. In fact, I would submit, show extraneous, independent evidence that could lead them to the truth. We repeatedly put that before them. They weren't concerned about that. They were happy to peddle these Mungiki witnesses into this court to tell lie after lie after lie. In our submission, we have come to the stage of these proceedings where Mr. Kenyatta is being brought into a dispute that had already been happening between the parties. I, as his lawyer, will exercise his defence rights as I consider them necessary and right to do so. Those decisions as to whether anyone had asked him, they wouldn't ask him. They would ask me, because he has given me the power of attorney to represent him. And no request would be us. Those are my submissions. Thank you.
Thank you, Mr. Kay.
Thank you very much. Any parties? Mr. Gaynor.
Madam President, very briefly, I'd like to make two submissions in response to what the Attorney General said.
Very briefly.
Yes,
please.
very briefly. He referred to the billions of shillings that have been given to victims in Kenya. Well, I've personally met 575 of them in 30 meetings. The vast majority have received virtually nothing from the government. A small number received 10,000 shillings from the government once, and a couple of others received 1 tin weighing 2 kilograms of maize meal. That's all they received for 6 years in order to feed their families. So his overall character of assistance given to victims of post-election violence, especially in the Western and Nyanza regions, falls far short of the complete story. Secondly, I'd like to address his suggestion, which I believe is around page 95 of the transcript, that the Cabinet never discussed ICC-related matters. Now, the government of Kenya took very strong positions at the United Nations Security Council, at the African Union, and to address his suggestion, which I believe is around page 95 of the transcript, that the Cabinet never discussed ICC-related. The Kenya delegation included the Attorney General, the Director of Public Prosecutions, the Minister for Foreign Affairs, and, for example, the head of the Witness Protection Agency, and they took 68, which is designed to deal with witness intimidation and witness bribery. They opposed it completely. They managed to put in the preamble of the resolution adopting Rule 68. They completely supported immunity for a sitting head of state from prosecution. They did that also at the African Union. If immunity was not to be, they took the position that the head of state should not be present.
Mr. Gaynor, I think it's not a suitable place to discuss the immunity issue.
If I can finalize in one sentence, if all those positions were taken without consultation with the President of Kenya, I would be extremely surprised. Thank you very much.
Thank you very much. If there are no other submissions, that brings us to the end of the matters to be discussed today. We thank very much parties and parties. Special thanks goes to the Mr. Attorney General and his team for their contributions and also for traveling to this city of The Hague. And I would also like to thank the interpreters, court reporters, especially for additional time given to us, and other courtroom staff for their assistance. This status conference is now closed and the court will rise.
All rise. We will there.